Due to a recording error during the September 10th webinar, we are re-recording this session, so it will not include the Q&A from the end of this session, but it will include all the information from the presentation. Welcome to the Open Meeting Law webinar with the Data Practices Office. Thanks for joining us today. For those of you who aren't familiar with our office, we are a statewide resource on data practices and the open meeting law. In addition to the in-person training we provide, we are just starting to offer short webinars on open meeting law and data practices topics. Today's webinar is the first in a series on the open meeting law. Given our short time together, it will be a pretty high-level overview of the requirements of the law. In future installments, we will talk more about specific issues like closing meetings and using interactive TV to conduct a meeting. Please share your suggestions for other topics that you would like to hear us cover, either the open meeting law or data practices. There will be a survey when you close out today's webinar, and we really appreciate it if you would provide us some feedback. You can also always leave us suggestions for future webinars at our email address, info.dpo@state.mn.us. So let's get right to it. The open meeting law is found in Chapter 13D of the Minnesota statutes. Those of you who have been working with it know that it's a fairly short law and contains some pretty clear technical requirements. The courts have also weighed in to clarify and in some cases complicate the analysis in different areas. The Minnesota Supreme Court has identified 3 policy objectives behind the open meeting law. The first is that public bodies should not meet in secret. The other is that transparency piece, the public's right to be informed. And thirdly, to give the public an opportunity to present its views. This third one is not reflected in the open meeting law. So how and whether public bodies decide to allow members of the public to speak at meetings is largely up to each public body. There may be some specific statutes related to your public body or the public body you represent that require public comment in certain circumstances. For instance, if you have statutes that require you to have a public hearing on particular matters or take comments from the public, but those requirements are not reflected in the open meeting law. So this is something that we get a question on fairly regularly about from the members of the public asking about talking at meetings. So that really is largely up to the discretion of the public body. What is a meeting? Well, the open meeting law does not give us a definition. So this is one of those areas where the Minnesota Supreme Court stepped in and provided us with clarification. In the 1983 Moberg case, the court said that a public body is holding a meeting when there is a quorum of voting members and those members are discussing, deciding, or receiving information as a group related to its official business. So if there are fewer than a quorum, or there is a quorum but they're not discussing, deciding, or receiving information as a group related to official business, then the group is not having a meeting, which would be subject to the open meeting law. So there are times when public body members may gather, but they are not meetings. In addition to groups of less than a quorum, chance or social gatherings, and in some cases trainings, would not be meetings, subject to the requirements. For example, if the entire school board is at the Friday night football game and they're talking about the weather or their kids, that would not be a meeting subject to the open meeting law. If the whole city council attends the retirement party for the police chief and they just stick to social topics or where they're traveling, that would not be a meeting. There are several opinions related to trainings. There's an attorney general opinion that predates Moberg, and there is an advisory opinion that says certain trainings do not constitute meetings for purposes of the open meeting law. It's always important to note that the public might see a quorum of members talking to one another and draw certain conclusions from that. So you want to keep in mind the appearance of impropriety. However, unless the gathering meets both of the conditions of Moberg, quorum plus discussing, deciding, and receiving information related to official business, then it's not a meeting, and the following requirements do not attach. There are 3 types of meetings, and the type of meeting determines the kind of notice a public body must provide. The first type of meeting is a regular meeting, and the requirements are that the public body keep a copy of the schedule on file at its office. The schedule should also list any interactive TV locations. No other notice is required, so public bodies can choose to post on their website or on their community calendar or post it on a bulletin board at the city community center. And that is really helpful to the public. I think though the places like the website are places that the public is going to look for notices of meetings, but the only notice requirement in the open meeting law for regular meetings is to keep it on file in your office. Special meetings have more requirements and limitations. A special meeting is any meeting that is not on the regular schedule. Notice needs to be posted 3 days in advance. It must be posted on the bulletin board or the meeting room door for local public bodies. State-level public bodies and only state-level public bodies may fulfill this requirement by posting on a website, or they can publish in the state register if they have time or inclination. So for local public bodies, this really is one of those old requirements that, because the law was written in the paper world, that you post on the door or on the bulletin board. But again, you can post on your website as a courtesy to your members of the public. The notice must include the date, time, place, and purpose. Discussion has to be limited to the purpose that you identify in the notice. Therefore, your notice cannot say the purpose of the meeting is to discuss new stoplights and then also say and any other business. Part of this limitation has to do with the fact that members of the public can ask to have notice of special meetings that are related to specific topics. So if a public body has not identified the specific purpose of the meeting, it cannot fulfill its responsibility to provide that more targeted notice. The third type of meeting is a special meeting. And a special meeting is, an emergency meeting. An emergency meeting is also a special meeting in the sense that it is not on the regular schedule of meetings. But it is an emergency, and therefore there isn't time to provide that 3 days notice. The term emergency is not defined in the open meeting law, so we really look at the dictionary definition when we need to interpret this provision. So the dictionary says it's sudden, it's urgent, usually unexpected, requiring immediate action. So essentially, it's circumstances, again, that will not allow for those 3 days to post for the usual special meeting. We have some advisory opinions that discuss emergency meetings and some of the circumstances where it may not have risen to the level of an emergency, like hiring a building inspector or discussing the construction of a community center. In terms of notice, public bodies only need to make a good faith effort to notify media outlets that have requested notice. The open meeting law does not generally require meeting minutes. Public bodies generally do take meeting minutes, and there may be some other statutes related to those public bodies that require some documentation of a meeting. The emergency meeting notice provision in the open meeting law is one of the few places that meetings are mentioned in the open meeting law. And basically, if anything other than the emergency is discussed, a public body must keep minutes. So if the school floods at 2 a.m. on a Tuesday and the school board has to decide what to do with the students, they can have an emergency meeting about it. But if they also discuss whether to add more faculty in the coming year, then the board would have to keep minutes of that discussion so that the public can know that that was also discussed. Closing meetings. Again, we'll talk more about this in future webinars, but just generally, meetings can be closed if permitted or must be closed if required by the open meeting law or another statute. Before closing a meeting, the public body must make a statement on the record. The statement must identify the legal authority, which means you could just cite the statute or describe the legal authority, and also describe what will be discussed. The courts have weighed in here and said that just saying that you're closing a meeting pursuant to the attorney-client privilege exception for a discussion of legal matters identifies the authority, but it does not describe with particularity the topic to be discussed. The open meeting law does not say, but we suggest as a best practice that a public body start its meeting in open session and make the statement on the record and then go into closed meeting. Similarly, we suggest you come out of closed session to end the meeting so that the public can know if the closed session was continued, adjourned, or if there was some other procedural consideration with finishing the closed session. All closed sessions, except those closed pursuant to the privilege, must be recorded and maintained, and those recordings are government data and would have to be and access would have to be provided according to Chapter 13. The open meeting law has a number of provisions for meetings that must be closed. Notably, there is no general personnel exception to the open meeting law. There are several personnel circumstances where a meeting can or must be closed. For instance, law enforcement misconduct or preliminary considerations of charges or allegations against an employee subject to the public body's authority must be closed. It's important to remember that the provision about preliminary consideration only applies to that narrow set of employees subject to the public body's authority. The employee at issue has the right to ask for the meeting to be open. Once the public body decides that discipline may be warranted, then subsequent meetings must be open to the public, even if private personnel data will be discussed. There are also a number of meetings that may be closed, so be up to the discretion of the public body. 13D03 provides that certain labor negotiation meetings must be closed. That section has some specific provisions around closing meetings, so you'll want to take a look at those before closing a meeting for labor negotiations. The other items on this slide are found in Section 13D05. Note again that a public body may close a meeting for a performance evaluation, but that the employee must be subject to its authority, and the employee may ask for the meeting to be opened. One note on attorney-client privilege, on the attorney-client privilege exception, particularly for those of you who practice in the private sector. In the open meeting law context, the scope of the privilege is narrower. So where the privilege would attach for the open meeting law, where the privilege would attach for general legal advice for other clients, it would not necessarily rise to the level of being able to close a meeting. It has to be more than just general legal advice, and that is from the Minnesota Supreme Court. There are a few other provisions to be aware of. Every public body should keep a journal of votes, and that needs to be available during regular business hours. Also, one copy of members' materials must be available in the meeting room during a meeting. We are going to talk about the open meeting law technology in a future webinar, but I did want to note that Section 13D02 was amended this past session to allow active military who might be on a secure base to attend meetings via interactive television. The general requirement is that any location where someone is attending via interactive TV must be open to the public. So for those in the military, they were unable to participate in meetings when they also were members of a public body because their location was not open to the public, and now they will be able to. Finally, there are remedies for violations of the open meeting law. As many of you know, this law does not really have robust enforcement or strict penalties. Generally, for an intentional violation, there is a fine. If there are 3 intentional violations, a public body member forfeits their office and is barred from holding that position for a number of years. However, the courts have interpreted that as 3 separate adjudications or violations. In the Funk case noted on the slide, several plaintiffs filed suit against several members of the Victoria City Council. They filed their suits individually, but the cases were consolidated into one, and the court held that the consolidated case was still just one violation in regard to the forfeiture clause in 13D06. Also, the courts have repeatedly said that reversal is not a remedy for open meeting law violations. So actions taken in a meeting that violate the open meeting law cannot be reversed by the courts. The remedies are listed in 13D06, and the court has said reversal is not one of them. So I know that was a whirlwind overview, a very high-level one, but that is our time for today. If we didn't get to your question, we will follow up with you. The notice for our next lunchtime webinar will go out soon, and we look forward to sharing some time together again in the near future.